Yeah, man. Whew, boy, as I said, I missed a lot, but no, I missed it all. I took my ass to sleep, but I seen Miss Tawana had tagged Too Strong in a commune post, and then Too Strong had went live and said some words. That's the first thing we're gonna play. Yeah, he went to work with his strap like Gilbert Arenas. I have been trying to DM Gilbert Arenas and get his attention. So 'cause I'm sure he would use that as his theme song if he know about it. Cause he, yeah, that's infamous Gilbert. He could play that on this show. But yeah, Too Strong, she had some words I did hear her say. I just heard the beginning because I'm gonna play it while we hear. And she said she just I know she said she got recordings or whatever the fuck went on. I think she said Bams was live and Buns was live, and she said she better hope while she at church that the Lord take the spirit of I'm gonna get you bitch out of her. I hope he don't, just me personally, because I want to hear what she got to say. I do. And I don't think none of our people got the video, so we can't review it. So if she don't review it, then we can't yeah, they go with it every couple months. It's what they do. That ain't nothing new for them. But yeah, hopefully Too Strong. She wear that bitch out because that's what she want. But first, this morning, about 20 minutes ago, I got the lawsuit and the response that YouTube and their powerful team of lawyers sent back to the court in the Shea Hall. Start off, they got an attorney named David Kramer. They got Kelly Noel on that joint. They got Wilson, Sonsini, Goodrich, and Rossetti all on this case. Let's see here. Case number 3.24. This is too much shit. But what this is, we're reading is defendant's notice of motion and motion to dismiss plaintiff's complaint before Honorable William H. Orrick, Courtroom 2, hearing date December 11th, 2024, time 2 p.m. Then these folks got a table of contents typed up. I had to say here, notice of motion, statement of requested relief and issues to be decided, memorandum of points and authorities, factual background, YouTube services, in terms of condition, plaintiff Hall and his claims against YouTube. Argument, plaintiff, which is Deshae Hall, fails to state a viable cause of action. Plaintiff fails to state a claim for copyright infringement. Count 5, I guess it's on his whatchamacallit. Plaintiff fails to state a valid breach of contract claim. Counts 1 and 3. Hall cannot state a claim for express breach. Hall fails to allege an implied breach. Hall cannot and does not state a tort claim based on YouTube's failure to remove or reinstate content. Then they just got annotated codes. They say 47 USC something 230 bars Hall's claims. The First Amendment bars Hall's claims. Hall fails to state negligence or torturous interference claims. They got this shit broke down. I'm not gonna read all this shit, but as y'all see, they is going through it. And let's see. Hall's damages claim is barred by the limitation of liability provision in the terms of service and the conclusion. Then they got a defendant's motion to dismiss. Now, table of authority, they're just listing a whole bunch of cases, and it appears they have 27 cases on the first page. The second page has another 27 cases. So it's the third, the fourth, the fifth. God damn. Wow, they have like 5 pages of just different cases that they've already spanked out. Then they show the statutes for all of these things in the rules. And then here's the notice of motion and motions. To all parties and their attorneys of record, please take notice that on December 11th, 2 o'clock, before blah, 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 YouTube shall and hereby does move for an order dismissing with prejudice all claims advanced by plaintiff in his complaint. The motion is based upon notice of motion, the supporting memorandum of points and authorities, the pleadings, records, and papers on file in this action, and argument of counsel and any other matters properly before the court. Statement of requested relief and issues to be decided pursuant to rule of the federal rules of civil procedure, yada, yada, yada. YouTube seeks a dismissal of plaintiff's complaint without leave to amend. That's saying, nigga, you don't get to bring this shit back. Oh, pro se plaintiff, meaning he ain't got no lawyer. Pro se plaintiff, Deshae Hall, has turned an online feud with another YouTuber user into a federal lawsuit and improperly directed it at YouTube. Son of a bitch. Shout out to YouTube's legal team for calling this shit what it is. This nigga got into it with MoneyBoy Trey and he want to sue us because MoneyBoy Trey whooped his ass. Give me a second, y'all. I got to blow my nose. Ooh. All right, y'all. All right, hold on. God damn it. No, I'm not in trouble. If I was in trouble, YouTube know what's up. YouTube know what's up. And they probably read that story he did, and I told the truth in it, jet. Man, this was a childish ass argument, and the nigga lost. Okay, where was I? Let's see here. Pro se defendant Deshae Hall has turned an online feud with another YouTube user into a federal lawsuit and improperly directed at YouTube. Yes, YouTube. He told y'all he was gonna sue y'all. He said it, not me. So I'm gonna sue YouTube because y'all letting them do it. Improperly directed it at YouTube. In the main, Hall claims that he was the target of false copyright infringement notices submitted by a YouTube user who goes by the name MoneyBoy Trey. He also accuses of harassing him across various social media platforms. According to Hall, YouTube should have taken his side in the feud and and contrives various theories as to why YouTube should be responsible for his claimed injury. Son of a bitch, YouTube did acknowledge me in the motion to dismiss. I'm a bad motherfucker. Now, YouTube is saying this lawsuit. YouTube has been all up and through my goddamn channel since this shit didn't happen. I ain't took one goddamn video down. I also don't talk about this nigga no more either. So I think it's fair to say that I'm good with YouTube. Because remember when he first started this shit, that's where he was running around. YouTube gonna take your channel down. He had that fat Della Reese Media, whatever the fuck her name is, coming over to my channel. Your channel going down. They gonna take your channel. It's going down. Wait till Shade take it. All you stupid motherfuckers that said that, I just gotta point out, they court date ain't here yet. They filed this on 10/16. Whenever he filed this goddamn motion, I'm sure they started looking at my goddamn channel. I ain't violated none of their terms or conditions. I didn't do nothing racist to that fat white bitch of a wife he got. I could call her fat and white. Again, that's why I stopped though. Okay. YouTube should have taken his side, and he contrives various theories as to why YouTube should be responsible for his claimed injuries. Plaintiff misdirected case fails. The complaint does not satisfy basic requirements for the copyright claim he tries to plead and misapprehends online service providers' obligations under the Digital Millennium Copyright Act. Contract claims against. In support of his claims, Hall attaches to his complaint over 100 pages of unorganized materials of unknown relevance. A hodgepodge of listen to the language they have written in their statement for you, nigga. They had fun writing this. They laughed at your shit. In support of his claims, Hall attaches to his complaint over 100 pages of unorganized materials of unknown relevance. Say, like, what the fuck does this have to do with anything? A hodgepodge of transcripts, screenshots, emails, reports to law enforcement, and YouTube pages. Who the hell he called the police on? Damn, he called the police on somebody? I know that couldn't have been on me. Especially with the shit that he was doing. But yeah, I don't think anything warranted the call of the police. Well, I know he called the police on Jed. Maybe that's what they're talking about. Law enforcement and YouTube pages. Because Hall's exhibits are not individually lettered or numbered, YouTube will refer to myriad of materials attached to the complaint by their ECF page numbers. Let's see. Defendant's motion to 28 that goes on. YouTube are barred by the plain terms of agreement he seeks to enforce, under which YouTube is free to display and remove content as it sees fit, and plaintiff's remaining claims for negligence and tortious interference are both barred by the federal statutory immunity for interactive service providers found in Section 230 by the First Amendment. The complaint should be dismissed. Factual background: YouTube and its terms and use of service. I ain't going through all of that. It just says, okay, to create a channel, they saying you okay, that's that. Ooh, they showing where each lawyer that contributed to this dismissal thing. To create a channel and post videos to the service, users like plaintiff Deshae Hall must agree to the terms of service and incorporated community guidelines. Users expressly acknowledge that YouTube is under no obligation to host or serve content. Hall identifies himself as a resident of the state of Oklahoma, but he attaches to his complaint in the terms of service using YouTube service in India. Oh shit. Hall identifies himself as a resident of the state of Oklahoma, but attached to his complaint the terms of service governing use of YouTube service in India. That's he had that fake ass Indian lawyer. Identifying service as YouTube India. Through the Indian terms of service overlaps in many respects with the TOS governing users in the United States. It is the domestic version that controls here. On a motion to dismiss, the court may consider materials that are judiciously notable. See, yeah, whatever. The plaintiff does not explicitly allege the contents in the documents. Continued. Agreement may cause YouTube. No, that's nothing. I don't care about that. Plaintiff Hall and his claims against YouTube. Hall operates multiple YouTube channels under variations of the name Late Night Crew or LNC. Plaintiff alleges that in April 2024, he became embroiled in a dispute with two YouTubers, MoneyBoy Trey and Jedediah Brown. God damn, dog. That spilled out across all social media platforms. That's a lie. I ain't talking about that nigga on nothing but YouTube. That's a lie. One of Hall's chief gripes is that MoneyBoy Trey sent YouTube multiple allegedly false takedown notices pursuant to the DMCA, alleging that the content on Hall's channels infringe MoneyBoy Trey's copyrights. These allegedly false notices caused the temporary suspension of Hall's channels under the YouTube copyright policies. Notice he did the same thing to me though, and they could see that too when they went through their shit. Let's see. Hall also accuses MoneyBoy Trey and Jedediah Brown of having made threatening, defamatory, and or racially charged statements directed to plaintiff and his wife. I ain't never threatened him. I didn't. I don't threaten these niggas on here. Didn't do nothing racial. I didn't defame them either. Now, I just talk shit about them, including on YouTube and Facebook. Yeah, he telling on Jed. For his part, Hall submitted DMCA. I'm live. Hold on. For his part, Hall submitted DMCA takedown notices to YouTube alleging that MoneyBoy Trey posted infringing company. Oh, so they did see it. Hall claims to be the original content creator of a video titled Tyler Hero featuring Christy. According to the complaint, MoneyBoy Trey allegedly uploaded a video to YouTube that, what does this say? It's a blank there, and then it goes to 23 that copied the contractual terms of service terms they're just issuing. How did they go to another thing like that? Whatever. Okay, that copied the entire visual content. I changed it though. I put music and I did a little censor and I made it go closer so you can see his titties. I chopped it up. Hall alleges that he submitted a DMCA takedown notice to YouTube on May 8th. After YouTube processed Hall's takedown notice and removed the video, MoneyBoy Trey responded with a supposedly false counter notification. YouTube restored the video in response to the counter notification. According to Hall, YouTube should have not reinstated MoneyBoy Trey's video because Hall notified YouTube that he had sued MoneyBoy Trey. It appears Hall did sue MoneyBoy Trey in the new copyright claims board. He didn't. Well, it ain't went through yet. But at least originally, Hall's case was not for copyright infringement of the Tyler Hero feature Christie, whatever. Rather, Hall claimed MoneyBoy Trey made misrepresentations in the counter notification sent to YouTube in violation. The content claims board twice dismissed Hall's claims. I didn't even fucking know. So this nigga took me to YouTube. Can I get my videos back then? Because they still down. They still down. The content claims board then denied his shit. Yeah, Jed sent me the link. He the one that sent me this. They can I get my videos back? So the content claim board then denied this nigga twice because he did it for 2 videos. Damn, so you just get smacked on your ass like Hammerhead. That what happened when Hammerhead try to sue people too. It just get back. They get smacked all on their ass. Oh, wait. Oh, this is a good read. I'm just on page 12 of 31. Nigga, they fit out a 31. Well, they did say you had hundreds of pages of evidence that's unrecognizable and not. Yeah, Jed the police. He told you the police, but apparently Jed made threatening, racial, and defamatory remarks towards Midis. Because that wasn't me. And I wasn't on Facebook talking about him neither. I stayed on YouTube. Okay, let's see where we at. I lost my spot. The content claims board twice dismissed Hall's claims. No, and she didn't put it in there. Hall then changed tactics and sued MoneyBoy Trey for infringement, but the Copyright Claims Board dismissed that too because Hall did not plead facts showing he actually owned the copyright in the video. Hall tried yet again with another case, and in that case too, the Copyright Claims Board rebuffed him. So saying this nigga done tried this shit like 4 or 5 times. I did not know. What it do, Chef? I did not know this nigga has just been getting his ass handed to him since May, and I ain't even know it. But I told y'all, I ain't been served nothing. Copyright Claim Board ain't hit me up for my side at all. They just looked at what he presented and was like, you crying, nigga, stop. You crying. Ooh. Oh, shit. So YouTube, I need my videos back, though, G. I need them back. Hall tried yet again with another case, and they rebuffed him, ruling Copyright Office records for the application to register the copyrights for the alleged infringed video indicate Late Night Crew LLC is the sole owner of the copyright, and so the claimant with the ownership interest required to raise an infringement claim. Damn. So you don't even have Deshae Hall tied into your Late Night Crew LLC. They said they said the Late Night Crew can make the claim, but not Deshae Hall. Deshae Hall is the one who made the claim, and they tired of seeing your shit. Oh, I'm putting this shit in a picture frame. Thank you for sending this, Jed. Cause we first sent it, I was like, it's the old. He just said, "Have you seen?" He said, "I don't think you've seen this, but." Looked like he in over his head. And I read the first one, like, wait, is this them responding back to him? He was like, yup. Like, oh shit. I love how they're painting me in an excellent light, by the way. I'm gonna send these attorneys a gift basket or something. With his claims against, hold on, let's see what. Yeah, is it proper? Does not show Deshae Hall Sr. is a proper claimant with the ownership interest required to raise an infringement claim. With his claims against MoneyBoy Trey failing, Hall chose to pursue YouTube instead. In this action, Hall contends that YouTube is liable for the copyright infringement to be asserted against MoneyBoy Trey because YouTube should have not reinstated the alleged infringing videos, but the Copyright Board ruled against you too, nigga. The Copyright Board ruled against you as well. So you say everybody wrong but you. Oh. Okay, there's so much writing. YouTube should have not reinstated the alleged infringing video. Hall also claims that YouTube improperly removed or failed to restore Hall's own videos for which YouTube received DMCA takedown notices. He takes further issue with YouTube's decision to remove only some, but not all of the third-party videos he found offensive and reported to YouTube because he found them offensive. And he generally faults YouTube for not taking immediate action in response to his numerous customer service complaints. They're going to kick this nigga off. Based on these allegations, Hall asserts claims for copyright infringement, breach of contract, negligence, and tortious interference. He seeks $70,000 in compensatory damages, $150,000 in statutory damages, and injunctive relief. To survive a motion under rule, instead, plaintiffs must allege factual content that allows the court to draw reasonable inference that the defendant is liable for the alleged misconduct. The court is not required to assume the truth of legal conclusion merely because they are cast in the form of factual allegations. It's more thing. And it just says plaintiff claims that YouTube is secondarily liable for MoneyBoy Trey's supposed infringement of the Tyler Hero featuring Christy video. He makes this claim despite having failed repeatedly in his pursuit of direct infringement claims against MoneyBoy Trey. The claim against YouTube is even more meritless. As a threshold matter, to state a claim for copyright infringement, a complaint must plausibly plead on its face copyright registrations covering the works that the defendant allegedly infringed. And they show more cases. Let's see where it goes back. Okay. Hall fails to allege that he obtained a copyright registration for Tyler Hero featuring Christie or any other work before this case was filed. So before the case was filed, he never tried to copyright anything. Can't do it after the fact and say you're suing. They did they work on you, nigga. They got that in quotations or any other work before this case was filed. Indeed, the complaint says nothing at all about the video registration statute. Further, a review of Copyright Office records indicates that Hall has not registered any copyrighted works. Late Night Crew LLC and LLC, which Hall appears to be associated with, has registered a few motion pictures with the Copyright Office, one which is identified as Tyler Hero Part 1, but did so weeks after Hall filed suit against YouTube on July 5th, 2024. Mm-hmm. Damn, Tyler Hero video. There's a motion picture, and that nigga used something. That's a basketball player name. Let's see. Importantly, plaintiff cannot cure their failure to meet the preconditions set forth in okay. So I don't know what that is. We trying to get some more good shit. Okay, for that reason alone, Hall's copyright claims against YouTube cannot proceed. They just list case law. Hall has another fatal problem. He lacks standing to sue for copyright infringement. Under the Copyright Act, only the legal or beneficial owner of an exclusive right under copyright is entitled to institute an action for any infringement of that particular right committed while he or she is the owner of it. Here, Hall claims to be the creator of the alleged infringed content, but does not plead facts sufficient to that show he is the owner of the work. As the Copyright Complaint Board recognized in dismissing Hall's direct infringement claims against MoneyBoy Trey over Tyler Hero, the Copyright Office records for the application to register the copyright for the alleged infringed video indicate that the Late Night Crew LLC is the sole owner of the copyright, not Hall. Let's see, and then they show in there Hall did not specify how Deshae Hall Sr. is the legal or beneficial owner of the work. So he thought he was smart. Even if Hall could surmount the lack of timely registration and standing, his copyright infringement claim is flawed beyond repair. As numerous courts have recognized, YouTube has robust DMCA procedures that shield it from liability for copyright infringement allegedly committed by its users. Hall acknowledges that the DMCA would bar his claim, but suggests that YouTube is not entitled to its protections because it supposedly failed to follow statutory procedures when it restored MoneyBoy Trey's video in response to his counter notification. Hall is incorrect. Hall first claims that YouTube did not inform him about the counter notifications as required, alleging plaintiff was not notified about the submission of the counter notification by MoneyBoy Trey. My name is all through this bitch. And thus no chance was provided to plaintiff to rebuke the counter notifications, create a further loss and damage. Within 3 months after the first publication of the work, according to complaint, Tyler Hero was created in February 2024 and published on TikTok. then allegedly infringed in May 2024. Assuming the work was registered with the Copyright Office et al. In August 2024, then statutory damages are not available. So it's just a lot of shit to read. And it's a PDF too. I put the PDF on my channel. My channel. What else are they saying in this thing? There's more cases. But Hall's own allegations refute that charge. Per the complaint, Hall sent YouTube but Hall's own allegations refute that charge that they notified you of my counter. So they saying you lying. You talk so much you forget that you did that. Hall's own allegations refute that charge. Per the complaint, Hall sent YouTube a DMCA takedown notice from MoneyBoy Trey's video on May 8th, 2024. MoneyBoy Trey submitted a counter notification to YouTube, and Hall wrote to YouTube complaining of the alleged falsity of the counter notification on May 11th. So you lied in your lawsuit? You lied and said them folk didn't notify you that I countered, but you wrote to them 3 days because you know I counter quick. You was like, what? Y'all let him beat it? Blew your case open. Oh, you're a liar, sir. Sir, you are a liar in federal court. This is in paper. This on paperwork. Hit the Cash App, y'all. He was trying to sue me. Hit the PayPal. Hit the Super Chat. Join the membership. Buy an album. Ooh, these niggas have been trying for the longest to fuck with your boy. They have. Wrote to YouTube complaining of the alleged falsity of the counter notification on May 11, 2024. See complaint. Plaintiff immediately recommunicated with YouTube on May 11th that the counter notification was false. In other words, Hall's complaint makes plain that he knew about the counter notification and promptly protested it. Given that his claim not to have received the counter notification is baseless, Hall also contends that YouTube should have not restored the allegedly infringing material because he sued MoneyBoy Trey in the CCB and informed YouTube that he had done so. In response to a counter notification, a service provider must. It just tells the terms of services. Hall contends his lawsuit in the Copyright Claims Board should have prevented restoration of the material, but as noted, Hall's Copyright Claims Board against MoneyBoy Trey was not for copyright infringement. The only claim Hall filed against MoneyBoy Trey during the relevant time window was for misrepresentation, not for copyright infringement, misrepresentation. Such an action does not stay a service provider's restoration of allegedly infringing materials following a counter notification. Even if there was a timely copyright registration in this case, and even if Hall had standing to sue for infringement, any claim against the attachment to plaintiff's complaint show that YouTube forwarded a counter notification on May 10th, 2024. He struck me on the 8th. On the 10th, they was like, nigga, he countered. Okay. Let's see here. What else do we have? YouTube would flounder in light of YouTube's DMCA protection. Hall also includes various claims alleging YouTube breached the terms of service agreement. First, he alleges YouTube failed to investigate or take immediate corrective action to restore his videos upon a receipt of complaints legal notices, including valid counter notifications. Second, he claims that YouTube failed to conduct a proper investigation into MoneyBoy Trey's false DMCA claims and his own harassment reports before terminating plaintiff's channels. Third, he reprises his claim that YouTube improperly restored MoneyBoy Trey's video. But the length of Hall's grievances list does not help him. To state a claim for breach of contract under California law, a plaintiff must identify not only the contract at issue, but also allege the specific provisions in the contract creating the obligations the defendant is said to have breached. and they list a filing there. Hall points to no promises in the terms of services that YouTube supposedly breached. Indeed, his claims are at odds with the actual terms of service. Insofar as plaintiff's contract, okay, how can I state a claim for express breach? Insofar as plaintiff contract claims are predicated on YouTube's removal of his content, plaintiff points to no contractual guarantee that YouTube would host his content, nor does he identify any promise by YouTube to initiate an immediate investigation into alleged false copyright takedowns or whatever. This claim is particularly mystifying in that Hall instructed YouTube support not to investigate false claims or to assist him further on multiple occasions. Wow, nigga, I ain't never seen that word before. They put this claim is a white woman typed it. This claim is particularly mystifying in that Hall instructed YouTube support not to investigate allegedly false claims. So don't investigate the false claims or to assist him further on multiple occasions. Mr. Hall told them, close all my cases. I'm contacting an attorney and do not consent YouTube doing any further investigation into the false DMCA claim. Close the cases. I do not need further help. Nigga, you typed this to YouTube and then you sued them? Oh, they're going to kick you off. I don't think you're going to make it to 2025, G. I don't think you're going to make it. They're going to find a reason to say you violated their terms of service. Oh, shit. I do not need any further help, copyright takedown notices, or take immediate corrective action upon the receipt of counter notice. What is this? That is because no such promise exists. All right. That's them just telling more talking. Further, any attempt to divine a contractual promise to protect Hall's channels against false takedown notices or to immediately reinstate content will be at odds with the express terms of the parties' agreement. And we just on page 19. Advertising defendant unfair. Plaintiff rattles off a litany of supposed breaches that he describes as YouTube ignoring customer service requests or failing to protect his channel from copyright notices he considers false, not that they're false, claiming YouTube failed to facilitate proper communication between parties in copyright disputes, claiming YouTube violated a promise that content licensed from the YouTube audio library would not result in copyright infringement claims. But all of these grievances run into the same basic problem. Plaintiff has not identified the express terms of the contract YouTube has allegedly violated. Any duty to immediately reinstate content or to protect plaintiff's channels from false takedown notices would also be at odds with, preempted by the DMCA. The DMCA does not contemplate immediate reinstatement of content upon receipt of counter notifications. Yada, 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 yada. That's more. They say his name in there anymore. Nope, more case law. Plaintiffs claim. Plaintiffs nevertheless claim that YouTube breached the terms of service by misapplying its policies when removing or restricting access to plaintiffs' content. Removing plaintiffs' videos or channels by misapplying policy concerning copyright, but plaintiffs' disagreement with how YouTube has enforced its policies does not amount to a breach of contract. To the contrary, because defendants were given the right to do what they did by the express provisions in the contract, there can be no breach. Equally flawed is any contract claim based on YouTube's alleged failure to remove third-party content that the plaintiff finds objectionable or that in his view violates YouTube community guidelines or other policies. YouTube failed to remove content in response to plaintiff's report. including content plaintiff considered infringing or harassing. The terms of service establish YouTube's discretion to enforce its community guidelines. They do not impose an obligation to do so in a given case, and certainly do not give each user a contractual right to insist on the removal of content the user finds objectionable. Somebody, Facebook's terms of service, they showing, boy, they killing your ass. YouTube does not make any specific commitments or warranties about the content provided through the service. YouTube cannot be charged with breaching non-existent provisions of the terms of service, much less imaginary provisions that contradict the actual terms accordingly. Hall has failed to make a state claim for breach of contract. Bro, they is wearing your ass out. I need to just, y'all know what? What are we on? We an hour in. Yeah, this is just gonna be the reading the lawsuit page, and then I'll stop this and come back with Too Strong in them. This is gonna be I don't want all that cut up. I'm just gonna do 3 different. I do 2 shows. Okay, Hall fails to allege implied breach for similar reasons. Hall has no viable implied covenant claims. His allegations add nothing to this claim for breach of contract. And Lewis versus Google. Care about that. Here we go. Something about PayPal has sole discretion. Okay. Hall cannot and does not state a tort claim based on YouTube's failure to remove or reinstate content. As an alternative means of challenging YouTube's decision over what content to host or remove from its service, Hall asserts state tort claims for negligence and tortious interference. The gist of the claims is the same. YouTube was negligent in failing to handle content the way Hall would like, and YouTube's failing interfered with some opportunity Hall claims to have had. These claims go nowhere. They say federal law grants online services sweeping protections over decisions that they make to host or remove any third-party content. Yikes. More reading. I said I wasn't going to read this whole thing, and here I am on page 23. More case law versus Twitter, such and such versus Google. Ninth Court. Okay. First, there can be no dispute that YouTube is an interactive computer service provider. Second, Hall claims are plainly based on content that he himself created and uploaded, describing montage of footage used in making the videos or that other YouTube users created and uploaded to the platform. There is no allegation that YouTube itself created or developed the content at issue, because that content was provided by another information content provider. The second steps in the Section 230 analysis is satisfied. I don't know what the fuck that is. Third, Hall's claims treat YouTube as a publisher by attacking YouTube's performance of traditional editorial functions. While presented under various causes of action, Hall theories of liability amount to redirect attacks on YouTube's decision to publish or withdraw third-party content, whether posted by Hall or other. These are classic examples of YouTube's exercise of editorial judgment, which falls squarely within Section 230. As the court in Pruger 2 explained, yada, yada, yada. Because all the elements of the Section 230 test are easily satisfied, the statute bars Hall's tort claims. The First Amendment bars Hall's claims. Hall's negligence and torturous interference claims seek to undermine YouTube's ability to determine what content will appear on its service. As a result, the claim conflicts with YouTube's First Amendment rights. Supreme Court recently reaffirmed the First Amendment rights of social media platforms, yada, yada, yada. Let's see. Hall seems to think that YouTube should face legal liability for its editorial decisions to publish and remove content on its platform. And he seeks an order compelling YouTube to make editorial choices different from those it has made. The First Amendment bars these claims. Hall seeks injunctive release requiring defendant to reinstate plaintiff's YouTube channels and to remove the infringing content from its platform, as well as an order enjoining defendant. And it's something. Hall fails to state negligence or tortious interference claims. Finally, Hall has not pled facts sufficient to state viable tort claims. Negligence. A negligence claim under the California law can arise only when the defendant owes the plaintiff a duty of care. Duty is not universal. Not every defendant owes every plaintiff a duty of care. Here, Hall alleges that YouTube owed him a duty of care to handle DMCA claim, harassment reports, and account management responsibly and diligently. Hold on, y'all. Let me drink. That's part of the reason I'm having these tongue twisters. Let's see. Here, Hall alleges YouTube owed him a duty of care to handle DCMA claims, harassment reports, account management responsibly and diligently. And he alleges YouTube breached that duty in various ways, all of which can be boiled down to YouTube's alleged removal or failure to reinstate Hall's content or YouTube's publication, or failure to remove others' content. The complaint, however, fails to identify the source of YouTube's supposed duty, or even what it would mean, for example, to handle account management in a manner Hall perceives as responsible and diligent. Numerous cases have rightly held, for a variety of reasons, that internet platforms do not owe a duty of care to their users with respect to handling of user content. More case law. Even if there was a duty, Hall's negligence claim is also barred by the economic loss rule. Generally speaking, under California law, there is no recovery in tort for negligently inflicted purely economic loss. And it explains purely economic losses as financial harm unaccompanied by physical or property damage. Plaintiff vaguely alleges that YouTube caused him significant harm, but the only actual non-speculative, non-conclusory harm plaintiff gestures at is the loss of income resulting from the temporary suspension of his channels. That supposed loss is purely economic in nature, and the economic loss rule bars it. Tortious interference. Hall claims that by removing his content in response to copyright infringement notices and by temporarily suspending his channels, YouTube intentionally disrupted the plaintiff's contractual relationship and engaged in intentional acts designed to disrupt plaintiff's prospective economic advantage. For a tortious interference with contract claim, a plaintiff must plead a valid contract between plaintiff and third party. YouTube's knowledge and intent to disrupt that contract, an actual breach or disruption of the contract. Undo that for the supposed contract. He vaguely alleges YouTube interfered with the plaintiff's contractual relationship with viewers, sponsors, and collaborators, but he fails to identify those agreements or to even name a single third party with whom he has had a contractual relationship. Exactly, because they knew that this nigga wasn't monetized at the time. They like, okay, bro, who is these sponsors that you had that you lost money from? Niggas think they can just lie in court and it'll go somewhere. Now, he knew this shit wasn't going nowhere because he filed it on his own. It was just a publicity stunt. But now they actually spanked this nigga. Are you gonna show up in court December 11th? I need to see if they got Zoom for this. You gonna show up in court, sir, and refile? But they want this thrown out without you ever being able to come back. That's what they want. or to even name a single third party with whom he had a contractual relationship. Hall likewise fails to allege YouTube had knowledge of any specific contract, much less an intent to disrupt it. More case law. Hall's vague assertion that YouTube's suspension of his channel impacted his ability to fulfill contractual obligations to advertisers and sponsors is not nearly sufficient. Then they got another Ad Trader Inc. versus Google, a whole bunch of cases. Hall fares no better with the claim for torturous interference with economic advantage. Here he fails to adequately plead the existence between the plaintiff and some third party of an economic relationship that contains the probability of future economic benefit to the plaintiff. At most, Hall points to his agreement with YouTube. At will agreement. Instead, he offers only he had a valid and reasonable expectation of future economic benefits from his YouTube channel, including revenue from ads, sponsorships, and donations. That conclusory assertion is properly disregarded. Hall must plead the specific relationship he had from which he stood to gain economic advantage. Hall's economic advantage claims fails too because he has not plausibly alleged YouTube committed any wrongful acts designed to disrupt some specific economic relationship. The law requires Hall to plead conduct that was independently wrongful beyond the fact of interference itself. Judge, you got to weigh light in this, Judge. They only said your name like twice. Okay, let's see here. To the extent that Hall is here referencing economic benefit that accrue to him as a result of payments from YouTube via YouTube's partnership program, which allows creators to monetize their content on YouTube. These benefits would arise from his relationship with YouTube, not with any third party, and therefore not relevant for his claim of intentional interference. Boy, they wearing your ass out. Hall's damages claims is barred by the limitations of liability provisions in the terms of service. I'm not going to read that. Both of the California Court of Appeal, Ninth Circuit have applied YouTube's yada, yada, yada. The same result is warranted here. Hall's damage claims are based on the removal or omission of his content in the presence of allegedly offensive content posted by others. Here too, the limitation of liability precludes Hall from recovering actual damages on contract and tort theories. Conclusion: for all these reasons, plaintiff's complaint should be dismissed without leave to amend. This respectfully submitted October 16th, 2024, Wilson, Sansoni, Goodrich, and Rosati. And then we got Kelly M. Knoll that signed that thing. And David Kramer and them. Declaration of Kelly Knoll in support of defendant's motion to dismiss plaintiff's complaint. Okay, she says, I am an attorney. I have worked as counsel on YouTube for nearly a decade. Attached is okay. Damn, this nigga done put me on. This nigga done put me on YouTube docket. Here we go. Oh my goodness, they got my name on this thing. Attached as Exhibit 4 is a true and accurate copy of the order dismissing claims without prejudice issued by the Copyright Claims Board on September 23rd, 2024. So damn, they just dismissed this shit. And Late Night Crew LLC et al. Versus Mark Abington, which I caused to be retrieved from and which remains available at the website. Attached as Exhibit 5 is a true and accurate copy of the docket for the Copyright Claims Case Hall versus et al. Abington docket. Which I caused to be retrieved from or remains. God damn, how many times did this motherfucker? Wow. So let's see. 4, 5, 6, 7, 8, 9, 10. They got 10 things. 10. They have listed on here 10 exhibits of where he went to the motherfucking copyright board on me. Let me read all these. Just let me go back through this. Just let's see. This first one is True YouTube Retrieve, which remains available. What's that? Okay, that's the attached as Exhibit 2 is a true and accurate copy of the docket for Copyright Claims Board, Late Night Crew versus Abington, docket number 24 CCB 0156. And she's saying she retrieved it. Exhibit 3 is Copyright Claims Board CCB 0156. Exhibit 4 is the Copyright Claims Board's dismissal of Copyright Claims Board 00156. Attached is Exhibit 5 of the true and accurate copy of the docket Copyright Claims Board Hall versus Abington CCB 0181. Attached as Exhibit 6 is a true and accurate copy of the claims filed on June 17th in Hall versus Abington. 7 is a true and accurate copy of the amended claim filed on August 10th, 24, Hall versus Abington. Exhibit 8, Hall versus Abington, another Copyright Claims Board order dismissing claims issued September 9th of the 0181. Attached number 9, true and accurate online copyright record. Okay. Exhibit 1. Are we still going through this? Oh shit. Oh, it's in. I got the. This is an 82-page PDF. I'm post a link on my community wall because that is one of the Exhibit 2. Okay, they got the paperwork on this thing. Case details for Late Night Crew LLC et al. Versus Abington. Amended claim, order dismissing claim. File date 9/23/2024. Case docket number 9, order dismissing claim. Then case 8 is amended claim. Send order non-compliant 7/7/25, Copyright Claim Board. Request for leave to amend claim, order to amend non-compliance claim. Order granting request to link Deshae Hall Senior with the Late Night Crew. He tried to link that shit up after the fact. Then they show status closed. Let's see, 5/21, status closed, parties, Deshae Hall, Late Night Crew, respondent, Mark Abington. They didn't contact me at all. Copyright Claims Board, Yukon. Yeah, that's pretty much the case. Oh, they showing the order dismissal without prejudice. Okay, Exhibit 4. Let's see what the Copyright Claims Board said. The Copyright Claims Board issued orders that notified the claimant on June 27th, 2024 and July 25th, 2025 that the claim and amended claim respectively did not comply with the applicable statutory and regulatory requirements for filings before the board. On August 10th, 2024, the claimant filed a second amended claim, which was the final opportunity to find a compliant claim. A copyright claims attorney reviewed the second amended claim and concluded that the claim does not allege a claim that the board can hear. In the second amended claim, the claimant changed their claim from a claim for misrepresentation to a copyright infringement claim. However, the copyright infringement claim does not specify how Deshae Hall Sr. is the legal or beneficial owner of the work or how the respondent had access to the work because it was on Facebook. He said he put it on TikTok. As such, the claim does not present facts sufficient for a claim of copyright infringement. The copyright claims attorney referred the second amended claim to a copyright claims officer to confirm that it does not comply with the applicable statutory and regulatory requirements, and that this proceeding should therefore be dismissed without prejudice. The copyright claims officer has reviewed the second amended claim and concurs with the finding of noncompliance. For the reasons set forth, the second amended claim does not present enough facts for the claim to proceed. Accordingly, the board dismissed the claims without prejudice and closes the case. Dismissal without prejudice means the allegations may be raised again by filing a new claim if there is no agreement with the respondent to the contrary. Case details for Hall versus Abington. Order dismissing claim 9-9. Boy, I'm whooping your ass and I ain't even know it. Jeez. What's this exhibit 6? Copyright cloud. They just showing where he went and changed it. Ooh, exhibit 7, another one. Boy, they did they due diligence on you. The other order dismissing the claim. The Copyright Claim Board issued orders on July 2nd and August 7th and notified the claimants that the claim and amended claim respectively do not comply with the applicable statutory and regulatory requirements for claims filed before the board. Both the claim and amended claim alleged misrepresentation. On August 10th, the claimant filed the second amended claim was the final opportunity. The second amended claim alleged copyright instead of misrepresentation. Copyright claims attorney reviewed the second amendment and the claim is non-compliant. Only a legal or beneficial owner of exclusive rights and copyright may raise an infringement claim. Copyright officer records for the application to register the copyright. The second amended claim does not show that Deshae Hall Sr. is a proper claimant with the ownership interest required to raise an infringement claim. An infringement claim must describe or show how the alleged infringing work is substantially similar to elements in the claimant's work and copyright protects. Second amended claim does not provide enough information describing the alleged infringement or describing the showing of the works to support. The board can only grant certain forms of relief. The second amended claim requests several impermissible remedies, like they wanted money. And then that fake ass lawyer emailed me and was talking about this why I cussed that lawyer out. And he talking about MoneyBoy Trey was scared. For what, nigga? I moved on with my life and I'm just seeing this shit today and they done been through you out on your ass. I didn't respond back to your lawyer talking about he was filing for me and public apologies and all that. I told both of y'all to suck my dick and I stood on it. The Second Amendment claims request several impermissible remedies, a declaration about the respondent's counter notices, a restraining order, and an order requiring YouTube to remove respondent's work. The copyright claims attorney referred the claim to a copyright claim officer to confirm it does not comply with the applicable requirements and that this proceeding should therefore be dismissed without prejudice. And closes this case. Dismissal without prejudice means the allegations be raised again by filing a claim if there is no agreement with the respondent to the contrary. If a complaint claim is filed naming only proper claimants, seeking only permissible remedies and presenting facts that support substantial similarity, the claim may proceed. This nigga wasted money on this shit. Breaking news. Tiffany is trying to block a rally. Okay, they showing this shit that he tried to do. Before this court is defendant's motion to dismiss plaintiff's complaint pursuant to Rules 12B6 by the Federal Rules of Civil Procedure on considering the briefs filed in support, therefore, in opposition to, and all other papers on file herein. Defendant's motion is hereby granted and plaintiff's complaint is dismissed with prejudice. It is so ordered. Wait a minute. This is filed 10/16 dated. Oh, but he ain't signed it though. But they just put it up there. They getting ready for the judge to dismiss this shit. Dismiss with prejudice. Okay. That's it, ladies and gentlemen. All right, that was an hour and 21 minutes. I played 15 minutes worth of music. Let me I'm gonna end this one. Then we're gonna come back and do the Faith, Too Strong, and the Dawes and the Thornton Township stuff. I need 2 separate lives. So I gotta go change the title. I gotta edit the music back out. I'm coming right back. I need about 25, 30 minutes because it's gonna take about 10 minutes maybe for the video to cut it out. And I gotta set up the new one and it'd be a whole bunch. But yeah, I will be right back. Never been a hoe, I stay on go, so what the business? Nigga talking reckless, shoot this bitch ass with the quickness. Now he bleeding, sorry, begging, asking for forgiveness. Bow, 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 Limp Biscuit. All my niggas wildin', they done labeled us some misfits. Wake up every morning, 2 or 3, 5 in the tidbit. Oh shit, didn't nobody come to see you old, it's some focus. Shoot 100 shots, no reloaded. Master of the game, you would think I'm into coded. Memphis niggas spit this pimpin', mackin' like I'm golden. Ho, with my money, you gon' turn me to the old me. Stay high, first class flight, I'm in the nosebleed. Copy, cooking, whipping, shipping, till you count the proceeds. OG, I've been moving back niggas since 03. Low key, niggas hating, but they don't want no beef. State gang, true sippers, bitch, I bet we don't eat. Get jammed, get a lawyer, make it bunny, don't speak. Pour up, oh, I need some more. A nigga had a long week. Shout out to my plug, he showed me love, he out in Long Beach. I'm true geek, walking by myself but left with 2 freaks. Ooh, we nothing in they mouth and on they booty. Austin Power swag, yeah baby, this is groovy. You can call me Money Boy or you can call me Nudie. Hood niggas, churches, chicken, let me get a 2-piece. Top down, 2-seater, let me feel the 2 breathe. Gotta hold it steady, chopper, kick it back like Bruce Lee. Lately I've been in the zone, I guess I'm in my 2-3. Don't call my phone for nothing less than a QP. Feeling like the Migos, cause my bitch is bad and bougie. All my haters love me, all these bitches just some groupies. Came a long way, I like to introduce the new me. Standing on business like I'm king or like I'm Drewski. Call me Ron Island cause I like my love for choosy. When we link it's a movie, she bustin' like a Uzi. I love the way she do me, I beat it up like Uzi. She dancing just like Suki. Call me Ron Island cause I love my love for choosy. When we link it's a movie, she bustin' like a Uzi. I love the way she do me, I beat it up like Uzi. She dancing just like Suki. I never been a hoe, I stay on go, so what the business? Niggas talking reckless, shoot his bitch ass with the quickness. Name pleading, sorry, begging, asking for forgiveness. Bow, 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 Limp Biscuit. Never been a hoe, I stay on go, so what the business? Nigga talking reckless, shoot his bitch ass with the quickness. Name pleading, sorry, begging, asking for forgiveness. Bow, 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 Limp Biscuit.